Hello everyone. Our next topic for the day is woman director. Now, in the last class, we have discussed about if we start with the provisions, appointment and qualification of director. We have just read about one provision so far in this particular chapter, which is section number 149.1, which states that every company needs to have directors. The directors will be individuals, minimum 1, 2 and 3 in OPC private and public companies, and maximum 15 directors in all types of companies. The limit of directorship can be increased, first proviso to section 149.1, by passing a special resolution. This is what we have read. Now this particular increase as well as the maximum limit is not applicable to government companies and not for profit making companies. So we have two exemptions also that we have read so far. Right, apart from that, we discussed that if in articles of association there is a lower limit which has been prescribed, so we need to alter our articles also as and when we want to increase the number of directors. Fine, and we did a question also in this regard. Now, so far things are clear, right? Section number 149.1 we are discussing. We are still not over with the subsection. So first proviso we have discussed. We move to the next proviso. As you all know, proviso, it carves out an exception or creates an exception to whatever is written as the main thing, right? It also at times give an additional thing. Now the second proviso states that such class or classes of companies as may be prescribed shall have at least one woman director. Okay, ma'am. So it is being told that some companies, every company will have directors, individuals will be directors and there will be minimum that many directors. But some companies, that is the first requirement that was being told to us, some companies will have one woman director also. Okay, ma'am. Why do you think this particular provision would have come into force at first place? Maybe because government wants to promote gender equality, women empowerment and all of that, right? This could be a probable reason. Now I'll share with you some framework or the background for this particular provision so that you actually understand it from all perspective. Firstly, government knew that okay, our constitution enshrines that about gender equality, but in the workplace we still don't find gender equality. The thoughts that I'm going to convey from now on till this particular topic is over is not mine, okay? So we are not going to debate upon feminism or women empowerment or ma'am you are saying this or you are saying that, nothing at all. It's just a way to convey my not again my thoughts, but actually to convey you what is established, what the survey says, what the study says, why it is so, and how this particular provision has been framed. Fine. So what happened is initially with this mindset of government introduced this particular provision. What happened was that the companies could not comply with this provision. 190 companies almost, I think, were penalized by SEBI for non-compliance also, and mostly the companies did not comply, right? In fact, their reason for non-compliance, as they suggested, was that they were unable to find qualified women for such position. See, if you have formed a company and you want to appoint some woman as a director, you cannot just go out on road and maybe you find a girl who's applying nail paint on her nails. You cannot say, oh, will you be the director of my company? I need a woman on board. Will you do it like that? Supposedly you hire her as a director of your company. What will happen is, she will go to the company, she will be a part of that board meeting, and when she is asked to say something, what do you think she will say? Oh, hi, I'm Monica, or something like that, right? So she will have her own swag probably because she doesn't know ABC of business. So you cannot force her to do something like that. So you need capable women. you are going to pay remunerations. Of course you need capable women, which is not as or you can simply say which is definitely not in abundance as we find men, right? Reason be whatever. So they could not find qualified women. Ultimately what they did is, in fact many big groups like Reliance, Videocon, JK Tires, Bajaj Group, all of these, they hired, who did they hire? Their family women as a part of their board. Like we have Neeta Ambani on the board of Reliance Industries Limited. So she is the woman director over there, right? So just like that, women of family of promoters were actually part of that board. So I would say that the appointments were made solely to post compliance without any change of heart. So it was exactly the same as it used to be, with no gender equality or no women empowerment. It was just for the sake of compliance, nothing else, if at all it was there. Otherwise a lot of companies were not complying with it even then. Now why I'm telling you all this, the reason is that this particular provision fails to actually, or it defeats the whole purpose why it was introduced. The reason being, if there are 15 directors on board, out of this, if I say the 14 directors are male and there is just one female director on board just for the sake of compliance, you're not letting that particular person grow. Probably she will find an unconducive environment, an inappropriate environment, maybe surrounded by not so appropriate people, you can say. So she will not probably find the space to grow, right? So no gender equality is going to be there, right? So this should be a requirement, or maybe the provision should be in such a manner that you should have probably independent women directors, not someone who's coming from the promoter family just for the sake of compliance. If you hire someone as independent woman director, you will probably count her opinion, right? So this should be somehow, maybe we can witness this particular change in future sometime. But as of now, this is a welcome move from the government. More importantly, government has introduced this particular provision for two reasons. One is gender equality, the other being, it is said. Again, I'm clarifying this point right here. It's not my view, it is what the studies and research says. That women are less exposed or less involved in frauds. Now many of the students who are male would probably suggest, no ma'am, meet my girlfriend, till you meet my girlfriend, she is, or till you meet my ex, right? So she is a big time cheat, or something like that, right? So get out of that. The real fact or the real truth is that if they are more empathetic, right? So if you're doing anything wrong with someone, they are probably the ones who will respond quickly. So in companies we need more transparency, we need more accountability, so women can bring another perspective, right? So that is also one such reason why women should be there as a part of the board of directors. Of course they should be qualified, they should be able to bring some insight and input to the company, and that's why they are appointed. Fine. So I hope this particular part is clear, right? So why women directors are being appointed. Now imagine imagine there are say 3 friends. Fine. There are these 3 friends, and these 3 friends have formed a company. Okay ma'am. Now one fine day, government brings up a notification, government brings up another law and says, just look at the woman out here, don't look at, okay, let me do it like this way. One fine day, government comes up with a rule that every company must have a woman, on board. Now these three friends who have formed the company, who are the sole members of the who are the members of the company, who are the directors of the company, they get this information. Okay, now some woman has to join us. What do you think they will think? And don't get your hopes high. Basically, they are not going to think and be excited and thrilled about it. They are basically going to think that, oh my God, we three friends, BFF, we have formed a company and now one girl will come and break our friendship. We are going to fight over a girl. No, no, this is not going to happen in my company. I don't want a girl out here. Business is business, right? So probably they would not want, or they will not have, they might not have someone so reliable and competent with them who can actually run the company in the same manner as they are doing. It's their private space, let it be private. The government cannot force them to do this, right? Which is absolutely correct. So government said that we are not introducing this particular provision for all types of companies. It is for some specific companies only. The companies which are operating on a very large scale, probably some seats in these large companies should be reserved for women so that they also get an opportunity to grow. So it is a kind of reservation that is happening over here. Say we have said Reliance Industries Limited. Arundhati Bhattacharya is also an independent director out there. Let's say there are some, actually just one I would say, in Reliance Industries Limited, or as of that matter, all the big companies, they all have one position which is vacant and reserved for women. Only women can occupy that particular position of director. So don't you think it's a welcome move for the women also to grow? Now some, again, male students might condemn this, that no ma'am, this should not happen. Everywhere woman is getting a reservation. In metros also their seats are reserved. So see, I am definitely not the one who supports reservation in any manner, but reservation, the whole intention of reservation is to promote someone who needs it, right? Probably, however, I know the times are changing and the times have changed and they're misused also. These a lot of benefits given to us are being misused also, which should not happen. But ideally, we need to uplift every section of the society which is not getting its adequate rights. So are women, right? So this was the thought of government, and government has introduced this particular provision. So if you have 15 directors who are male on board of directors, it's not okay. But if you have 15 directors, women who are on board, it's okay. Okay. So ma'am, what type of companies require at least one woman director? Listed company. What are listed companies? Listed companies are the ones whose securities are listed on a recognized stock exchange. What is stock exchange? Stock exchange is nothing but a marketplace. It's nothing but a marketplace where the securities are being sold and being purchased. Just like I have Flipkart, just like I have OLX, right? I list my product, someone buys it, right? Someone can sell product, right? So if I want my product to be sold on Flipkart, what I have to do is I have to list myself as a seller. Likewise, the companies do. The company want that my shares should be traded in this particular market. So I have to list my share over there. So I become a listed company. I want, what happens in the stock market? What is happening? It's a marketplace. I want to sell these shares at this particular price. So I'm bidding. Someone wants to buy it, they'll buy it. So buy, sell, buy, sell, buy, sell. This is what happens in the stock market, right? Okay. So that is listed company. Listed company. In private companies, there is no requirement of woman director. Mark my words, in private companies, there is no requirement of woman director. As I told you, there are three friends, let them be in their own space. We cannot force them to do that, right? So, listed company. Public company, public company with paid up capital more than or equal to 100 crores or turnover more than or equal to 300 crores. This is the requirement. Once again, and you have to prompt with me, if it's a listed company or it's not a listed company. If it's a listed company, we don't have to check any paid up share capital limit, any turnover limit, nothing. If it's a listed company, straight away you have to appoint one woman director. Now, if there are 15 directors on board, right, 15 directors. If there are 15 directors, any director may be a woman director. That means a woman director can be executive director, can be non-executive director, it can be part-time director, it can be full-time director, it can be managing director, it can be independent director, any director. See, I am not going to be appointed, oh, you are appointed as a woman director. Woman director is not a designation that you are going to give it to someone. It's about a gender thing, right? So I appoint someone, I am appointing that particular person as managing director. But amongst all the director, one person, at least one director has to be female. So it's a gender thing, right? Okay. So if listed company, nothing else to be seen, one woman director mandatory. Otherwise, public company with paid up capital 100 crores or more, with turnover 300 crores or more. Ma'am, both these conditions have to be satisfied? No, just one condition. Either of the condition is satisfied, you need to have one woman director. Fine, ma'am. Supposedly, I incorporated the company on 15th May 2023. So, the financial year ends on 31st March 2024. The financial year ends, financial statements are prepared, audit is being done, and then we have a set of ready audited financial statements, and this happens every year. In this audited financial statements, we will have a P&L account and we will have a balance sheet. In balance sheet, we'll have paid up share capital, and in turnover P&L account, we will have turnover. So every year, we check this limit. From the audited financial statements. If it is exceeding, then we appoint a woman director. Clear? If it's not exceeding, we don't need a woman director. So woman director is for big companies. That's why I told you the whole purpose to bring this particular provision has not been accomplished yet. Anyways, I hope so far things are clear. So section 149(1), what we have studied so far, minimum number of directors, maximum number of directors, they can be increased by SR, there is exemption to certain types of companies, right? So this is what we have read so far. In the second proviso, we read about woman director. So not all companies need woman directors, some companies need woman director. Which companies need woman director? The companies which are prescribed. Right over here, whenever, throughout Companies Act 2013, wherever you see as may be prescribed, we switch to rules which are framed by government. So we have a lot of rules. For this particular chapter, we have companies appointment and qualification of director rules. In that rules, there is rule number 3. And rule number 3 tells us that these companies have been prescribed and such companies must have at least one woman director on their board. Okay. So if they choose to have 5 directors, they must have one woman director. 4 directors can be male, 1 has to be female. There can be all 5 female also. Okay. You will not use the word female and male when you're writing answers, because what is important is to write the keywords. So although female and woman is the same thing, but you will use one woman director as has been used under the Act. I hope that's clear. Okay. Now there is a slight confusion in this particular part, so I'll take up this later. Before that, I'm going to move to another part. This is a company, wonderful company. Why is it a wonderful company, ma'am? See how many directors are there in this company. 1, 2, 3, 4, 5, 6, 7 and 8. So it's a listed company. It has 8 directors. Out of these 8 directors, I can say that man and woman. Man director and woman director. Man director, I think there are 5 and woman director are 3. 1, 2 and 3. So 3 woman director and 5 man director. Listed company. That means a public company. Ma'am, all listed companies are public companies. No, it wasn't so. A private company may also be listed, but if we go by the definition of listed company which has been prescribed for Companies Act, it includes only those public companies which have listed their shares. If the public company has listed its debentures, which was not issued through public issue, so if that is the case, then also that public company will also not be treated as listed company. Anyway, you don't be confused about it. You don't be confused about it. You just have to keep in mind that private companies are not listed, are not considered as listed in any manner under Companies Act. Fine. Although they are permitted to list their debt securities on a stock exchange. Okay. Now, it's a listed company. So it must have at least 3 directors. It has it. All the 3 directors must be individuals. They are. Maximum number of directors 15. 8 directors, so within that limit. And such company must have at least 1 woman director. It has 3 women director. Great. All the provisions have been complied with. All the provisions have been complied with. Right? Do you find any problem in this? Ma'am, I don't find any problem. Not at all. Okay. We move to the next type of company. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 directors. Okay. She is female and rest all are male. 9 directors. We have 8 man directors and 1 woman director. Again a listed company. Is there any problem? No ma'am, not at all. All the provisions have been complied with. Right? Or let's not take it as a listed company. Let's take it as a public company with paid up share capital. Paid up share capital 120 crores. Is this company required to appoint a woman director? Yes, because 3 types of companies require woman director. Listed company, public company with paid up share capital 100 crores or more, and or turnover, public companies with turnover 300 crores or more. So listed, paid up capital 100, turnover 300 or more. Listed 100, 300. Listed, paid up capital 100, turnover 300. Repeat it 2-3 times, you will be able to easily remember it. Now comes the confusion and the problem. What happens is, this particular female gets married. Now that's the problem. Marriage is actually a problem to a lot of problems. And anyways, so she gets married and she resigns. So she leaves the company. Now we have 8 man directors. 8 directors in a company is fine, but you must have 1 woman director also. This will actually lead to non-compliance of second proviso to section 149 1. And this, my dear, is known as intermittent vacancy. Intermittent vacancy. See, when we check at the audited financial statements at annual general meeting, we know that now is the need for women directors, and at a general meeting we can appoint a woman director. It is being proposed, and so she is appointed. In what manner, we'll discuss later, because we don't know anything about the procedure of appointment as of now, right? So that's a different thing. Here the vacancy has arisen in between two meetings. Suddenly it has arisen and we need to fill this vacancy. This is known as intermittent vacancy. Vacancy between two meetings. This has arisen. There is a vacancy. There is a vacancy and this needs to be filled. How is it going to be filled, ma'am? We have a provision for that. Any intermittent vacancy of a woman director shall be filled up by the board. So the board of directors, they are going to go and find some woman who is going to take the place of that woman director. Okay, ma'am. So it is filled by whom? It is filled by the board of directors. By when? That is my next question. By when? By when? Supposedly, woman has resigned on 15th April 2023. Okay. A board meeting is being conducted on 15th May 2023. 14th July 2023. These are 3 months. Okay, so this is case 1 and we have case 2. Date of vacancy, date of board meeting and 3 months, you know. 15th April 2023, here is the date of vacancy when she has resigned, when that intermittent vacancy has been created. 14th July 2023 and I would say 30th July 2023 is the date of board meeting. Okay. So I have given you 2 cases over here. I have given you 2 cases over here. In the first case, this is also 3 months. In the first case, vacancy has arisen on 15th April 2023. So on 15th April, we know that we need a woman director. We get a time period. It has to be filled by board. Right, the board will endeavor to appoint a woman director as early as possible. So board will appoint a woman director at the earliest, but we have been given a last date also, but not later than. What is the last date by which appointment must be made? What is the last date? The last date is being written first board meeting or 3 months, whichever is later. So we have this date. This is the date. So by 14th July 2023, intermittent vacancy of woman director must be filled by board. If we move to case number 2, vacancy is over here and again last date is first board meeting held after vacancy or 3 months, whichever is later. So this is later over here. This is later over here, right? So I hope you get it. So last date in this case is this and in this case is this. Now, some students might have another confusion. They might raise a question like this, that ma'am, supposedly. 15th April 2023, the vacancy arises. 3 months expire on 14th July. 3 months expire on 14th July, but the board does not meet. They have not conducted any meeting. They conduct first meeting after vacancy in, say, March. Or let's say, for example, let's not move to March, let's say in September. So on 15th September they meet. So now the vacancy, the position of a woman director will remain vacant for so long. Don't you think this is a kind of loophole in law? Well, I would say no. Why? Because you write one line. You write a line. You write a line, gap between two board meetings can't exceed 120 days according to section 173. So gap between two board meetings can't exceed 120 days according to section 173. That means if the last board meeting was somewhere around here, the next board meeting has to happen within 120 days. 120 days means what? 4 months, right? If we calculate 30 days in each. So anyways, if meeting is held over here, it will be held within 4 months, right? This we will read, this section we will read later, but I'm just giving you an idea that if you have this confusion that the board is not going to conduct meeting for so long and the position will remain vacant, no, it's not so. Within 4 months, anyway, they have to conduct a board meeting, right? Okay, so I hope you have got this particular thing. So any intermittent vacancy of a woman director has to be filled by board within next board meeting or 3 months, whichever is later. Okay, ma'am, I get it. We come back to our situation. There were 9 directors, right? There are still 9 directors. Now, she is female and she is also female. We have 2 females. That means we have 2 women directors on board. So out of these 9 directors, 7 are man and 2 are women director. Okay. This female, she gets married. She gets married and she resigns. What will she do? Oh, my friend is going, I'm also going to go. No, she's not going to do anything like that. What is going to happen is she's going to stay there. She also has a career to pursue. So she's going to stay there. Now what is happening? We have 8 directors, out of which 7 are man and 1 is woman. Do you think there is a non-compliance? No, ma'am. There is no non-compliance. We need to have 1 woman director, we have 1 woman director. So this will not mean an intermittent vacancy. Here the position of woman director is not vacant. There has to be 1 woman director on board. That is what the law says, and there is 1 woman director on board. So we cannot say that this is a case of intermittent vacancy which must be filled. No. As long as there is 1 woman director on board, you don't need to, right? If you want to appoint another person, you can go ahead and by following the normal procedure, you can appoint. That's not a problem. But this will not be treated as intermittent vacancy. I hope that's clear. Okay. So, some classes of companies must have 1 woman director. Which classes of companies given under Rule 3? Listed company, public company paid up capital 100 crores, public company turnover 300 crores. Not applicable to private company, listed 100, 300, right? That is what you have to remember. And after you remember this, if there is intermittent vacancy, it has to be filled by the board within 3 months or first board meeting, whichever is later. First board meeting, don't use the word first board meeting, you can use the word immediate next board meeting. So whichever next board meeting happens after this vacancy has been created. Okay, so immediate next board meeting or 3 months, whichever is later. I hope so far things are clear. Now is the point of confusion. What confusion is now going to be created? Okay, let's have a look. Supposedly, we incorporate a company on 15th May 2023 as I discussed. The financial year is going to end on 31st March 2024. After that, the financial statements will be prepared, they will be audited, we have audited financial statements, and then we will have the figures of turnover and all ready with us, right? Turnover, paid up share capital and all that like part, right? Then it will be ready with us. We know that three types of companies have to comply with the requirement of at least one woman director listed, 100 crore capital or 300 crore turnover. Fine, ma'am. Read it. Read something. A company which has been incorporated under the Act. Okay, fine. And is covered under second proviso to section 149(1) shall comply with such provisions within a period of 6 months from the date of its incorporation. That means you have June, July, August, September, October, November. Okay. 15th November 2023. We form a company. If this is applicable to this company, then it has to appoint a woman director within this particular period of 6 months. You tell me logically, if a new company is incorporated, its turnover cannot be determined on the first day. That you are giving it 6 months to appoint a woman director. Obviously not. Once its financials are prepared, then it will have a turnover ready. And then if you are going to appoint the woman director, it will not fall within 6 months of incorporation. Not possible. So this point is not possible. Moreover, when we actually form a company, it is formed with authorized capital. The paid up capital, the capital is issued after it is formed. Right, so we cannot say that we will have a paid up capital as on the first day, but yes, to a certain extent we can say that this is a company which has been formed and which goes for say 130 crore paid up share capital. So this company has to comply within 6 months and appoint a woman director. That is something which can still be justified, although not completely, but it can be justified, right? So I can conclude that if a new company is incorporated as on date and it either gets itself listed immediately or it is being formed with more than 100 crore paid up share capital, so it has got a time period of 6 months to appoint a woman director. And thereafter you might ask me, ma'am, what if the company gets listed over here? Now within what particular time period it has to appoint a woman director? So practically this is treated as a case of intermittent vacancy, and in the next board meeting a woman director is appointed just to comply with the law and be in safe side. Although exactly this has not been specified in the Act. Fine. Ma'am, since it has not been exactly specified and there is not much clarity, what we will write if a question like this is asked in examination? See, you will never be asked about something which is not there. Right? There can be a provision with two opinions, and at that particular point of time we follow the opinion given by the institute. But what if the provision is only not there? Institute is never going to ask you a question on something which does not exist, or for something where there is a ample scope of confusion. Okay, so they ask you provisions about crisp clear, they ask you questions about crisp clear provisions only. So such confusing thing, it will never be asked in examination. Any hypothetical query or situation that you create in your mind, trust me, it's never going to be asked in examination, because it is law. What is there, only that will be asked. This is a beautiful thing about this particular subject. So you have a limited scope only. You cannot say that this question was out of syllabus. What is there in law, they will ask only that. Okay, just you have to learn about that particular interpretation. You don't have to learn about anything else. Okay, now we move further. Although I have clarified you this particular thing, that if a company is newly incorporated, then within 6 months of incorporation, it has to comply with the provision of women director if anything is attracted to them. This particular thing cannot be attracted, that you know very well, right? Otherwise, for all these companies, they must have a women director. Women director are also appointed in general meetings only as any other director. You can in fact write a line over here: directors are appointed in general meeting unless otherwise stated. That means if it is given anywhere else that you have to appoint director, or board is going to appoint director, as over here, the intermittent vacancy of women director is going to be filled by board. That means members here are not going to appoint the directors. So if it is written something like that, then that provision will be applicable. Otherwise, in all cases, any director is appointed at general meeting only, be it executive director or non-executive director, any type of director. Okay, I hope that's clear. Fine. So company, if it complies with any of these three conditions, it will appoint at least one woman director. Any intermittent vacancy has to be filled by the board within the time limit, that is later of next board meeting or 3 months. Thing. Okay. So I hope this particular part is clear. Fine. Before we move on to the next part, that is resident director, let's look at a question. Question number 2. We have not done question number 2 also, but we'll do it a little later after we are done with section 149. We are going to do question number 3. Okay. Question number 3. Sky Limited. Sky Limited. A listed company has been incorporated under the Companies Act 2013. An intermittent vacancy of a woman director has arisen on 15th June. 15th June 2018. It's a listed company. So listed company, you must have a woman director, and an intermittent vacancy has arisen. So what you are going to do is, you have to compute the time limit probably. Time limit is going to be 3 months from here. July, August, September. So I can say on or before 14th September 2018, this vacancy has to be filled. Intermittent vacancy is filled by board within 3 months or next board meeting, whichever is later. Okay, so our next board meeting is on 14th August. 14th August 2018. So which is later? This is going to be the date. But how do we write the answer? We will first state the provision. According to second proviso to section 149(1) of Companies Act 2013, at least one woman director has to be on the board for the companies prescribed. You will write which companies are prescribed. You will write this. that listed company, public company with such paid up capital, public company with such turnover 100, 300 have to appoint a woman director. Okay. If any intermittent vacancy is arised, it has to be filled by the board at the earliest, but not later than immediate next board meeting of 3 months from the date of such vacancy, whichever is later. In the given case, intermittent vacancy has arisen on 15 June and the said vacancy has to be filled up by the board later of the 2 dates. You write it like this: later of next board meeting, that is on this particular date, 3 months, that is on this. Hence, the vacancy has to be filled by 14 September 2018. 18. Okay, clear? Fine. Now, we move to the next provision. This next question we will do after we are done with the resident director. So question number 4 we are not doing right now. We again move to our section. Section 149(1), and there are 2 provisos, very important proviso. First proviso about SR, second proviso about women director. Section 149 subsection 2, it is nothing, obsolete. It only tells us that the companies who were existing when these provisions came into force, they have a time period of 1 year to comply with the same. You don't have to study, you will never be asked this. Fine, so you will not find it, but students are curious, ma'am, 149(1) you told, and then 149(3) you told, where is 149(2)? So I'm just telling you. Okay, now section 149 subsection 3, it is about resident director. Who is a resident? Ma'am, you will tell who is a resident. How do we know who is a resident? A resident, you know now, who stays in India, right? I am a resident of India. I am a citizen also of India and I stay in India. I am a resident also. We have different residential status according to Income Tax Act. We have a different way to calculate. Under Companies Act, we have a different way to calculate. So you have to remember about Companies Act when you are reading about company law. Okay, ma'am. Now, supposedly, there are 5 directors in a company. Okay, so we have a company. Because company is an artificial person, we hired these 5 directors. These 5 directors were appointed to manage the company. Now these 5 directors, what do I call them? They all are I don't know actually. Anyways, let's leave it. I hope you have heard the word nalayak. Maybe you know it. Even if you don't know it, I really don't know what is actually. Anyway, they are such stupid people that they don't care about the company. All they care for is that I have to go to Pattaya, I have to go to Thailand, I have to go to Malaysia, I have to go to Singapore, and they're all roaming here and there, here and there. They should roam. They are earning huge money. They have full right to roam wherever they want to. They have full right to enjoy holidays. So they are doing that. No problem. An officer of the company, he came to the boardroom to get the signature of any one director on a document. He did not find the director. He came the next day, next month. For 10 months he came and he could not find a single director in the boardroom. Wherever their cabin was, he could not find anyone. That's not the point, right? Wherever they said, he could not find them. Do you think that if none of the directors are present, the decisions of the company will be delayed? You will not be able to call board meeting. You will not be able to call general meeting. You will not be able to get the documents signed. A lot of decisions will be delayed. Probably in the online era, we cannot exactly say that this huge problem will occur, but the law is made sometimes back, and even today we need people to be there, right, to take decisions. And that's why we have appointed directors, because company is not competent to take decisions on its own. It is an artificial person, right? So lawmakers said that this is not how a company would work. Probably you all want to go out, have business deals, go for holidays, it's okay. But there should be at least one person who is going to stay in India. He said, throughout in India only. He said, no, he should stay in India for at least 182 days. For at least 182 days, he should stay in India. At least one person who stays in India. Who stays in India for at least 182 days. That means if we are talking about financial year 22-23, it has 365 days. Out of these 365 days, he should have been in India for at least 182 days. Then he will be treated as a resident director, and every company must have a resident director. Every company. Not that prescribed classes of companies. Every company. Because even if it is a private company, you need someone to take decision. Company cannot take decisions on its own. Even if it is a one-person company, you need someone to take decision. Right? So there should be one director who is going to be a resident director in every company. If the company has 15 directors, out of this, anyone can be resident. This resident can be an executive director. He can be a non-executive director. That means he can be whole-time director. He can be part-time director. He can be independent director. He can be managing director. He can be anyone. So he can occupy any of those designation or the position. But he has to stay in India for at least 182 days in the financial year. I hope so far things are clear. Okay, so every company shall have at least one director who stays in India for a total period of at least 182 days. Okay, now there is an ironical thing, not exactly ironical, but if you remember about a company as one person company, OPC. In OPC, there is just one member, a sole member. Earlier, the requirement was that this member has to be a natural person, he has to be a citizen of India, and he has to be a resident of India. Then only he can form a company. He is the sole member. He may be the only director of the company. That's also possible. In one person company, we can have just one director, maybe the only director of company. So if he is the only director of the company, and one person company must have one resident director. Earlier there was no problem, but pursuant to amendments, this has been striked off. That means now a non-resident may be the sole member and the director of the company. But here, when we come to this particular section, we come to realize that every company must have a resident director. So if this is the case, either you become resident or appoint a resident director. Appoint a resident director. Right? So just I would say just a study tip that I have given you over here. Clear? Fine. Now, one more thing. A company was formed. Just a second. A company was formed. The financial year ends on 31st March 2024. Here a company was formed, and when the company was formed, there were just 200 days left in the financial year. It happens, no? If I formed a company on 1st May, 1 month has already been passed. Now, this was formed by 4 friends. And they all had planned a trip to Bangkok. They all had planned a trip to Bangkok for 20 days. Okay. So they formed a company. They are the 4 friends. They are the directors of the company also. And they planned a trip to Bangkok for 20 days. If they go to Bangkok in this particular financial year, they will be in India for only 180 days. That means none of them will be a resident director. This will lead to non-compliance, right? Now these friends were very angry at the lawmakers. They said this is not fair. If a company has 365 days in a financial year, you ask their directors to stay in India for just 182 days out of 365 days. And you are asking us to stay for 182 days out of just 200 days because we have 200 days only. So the lawmakers said, yes, they are absolutely correct. They should not stay for 200 days. They should probably stay here proportionately, and they will be treated as resident director. What will be the come out to be the proportion? 199 point something, right? That means in case of newly incorporated company, the requirement under this subsection shall apply proportionately at the end of the financial year in which it is incorporated. Fine? So I think so far it is clear. Okay. We move to the question bank again. Come back to the question bank. Question number 4. Sleeping Limited is a listed company. It is incorporated on 1st January 2018. The board of directors of the company decide to appoint in its board woman director and resident director. State whether it is mandatory for the company to do so. See, resident director is needed in every company, so yes. And woman director is needed in listed company, so again yes for both. What would be your answer in case the company is a non-listed company? See, it is a non-listed company and we have not been given information about the paid up capital and turnover, so we will say, okay, fine, not required. Third case, what would be your answer in case the company is not listed? Okay. See, listed, paid up share capital more than equal to 100 CR or turnover more than equal to 300 CR. So condition number 1 has been striked out because it's not listed. Paid up share capital is 50 crores. So again condition number 2 also striked out because it's less than 100 crores. And turnover only 200 crores. Oh ho ho ho. So none of the criteria is fulfilled. Hence it's not required to appoint a woman director. How do we write answer to such a question, ma'am? How do we write answer to such a question? What you have to do is you have to first write the provision. Provision about when a woman director is needed and when a resident director is needed. Based on that, in the first case, it is required. In the second case, it is not mandatory. And in the third case also, it is not mandatory. Right? Okay. Now we come to question number 2. Because we have not done that particular question. Question number 2. Question number 2. Okay. As per their articles, The maximum number of directors of each of the following companies is 9. That means we have been given 3 companies, and according to their articles of association, maximum number of directors is 9. And according to the Act, we have the maximum number of directors that may be appointed as 50. Okay. First company, Goodhart Company Limited. Second company, Frontline Trading Private Limited. And third company, Hindustan Zinc Limited, which is a government company. Government companies and not-for-profit companies are exempted from that upper limit. I hope you remember. So they don't have any maximum number of directors limit on them. Board of Directors proposes to increase the number of directors to 15. Oh my God, it's within the Act. A company may have maximum 15 directors. There is absolutely no problem in that. So they can go ahead and appoint 15 directors, no problem at all. Fine, ma'am. But the articles of association put an upper limit of 9 only. So you need to alter this article of association. How do we alter this? Section 14 tells us that we have to alter it by passing special resolution. So for this, we don't need any permission because it is within the limit. No SR is needed to be passed because SR is required when you want to appoint more than 15 directors. If you want to appoint directors up to 15, no SR is needed. However, because your articles say only 9, you have to alter the articles. That is the only action needed from company's end. So you will state the provision under section 149. This is given, and in the case of first 2 companies, maximum limit is 15. Hence you can go ahead and appoint 6 more directors, not a problem. However, if the number of directors was beyond 15, then you would have needed SR. Okay, not a problem. Maximum number of directors will require articles of association to be altered. Hence, special resolution will be required to alter the articles of association. And in case of government company, they are being exempted. Hence, they can go ahead and appoint as many directors as they want to. Okay? Yes, ma'am. I can hear that. I can hear this all the time, I think so. Okay, so next, independent director. See, section 149(1) with two proviso, we read about minimum and maximum directors and women director. Section 149(2), I told you it's nothing, right? They get a time period of 1 year that has been given. Old companies get 1 year to comply with new laws. That's it. If you want to write, you can write. Old companies get 1 year to comply with new laws. Simple. Section 149(3), it is about resident director. And starting from section 149(4) till section 149(13), we have provisions with respect to independent directors. Who are independent directors? They are non-executive directors. They bring an independent perspective to the company, a lot of knowledge, expert knowledge, insights, a lot of things, right? Who can be independent director, who can't be independent director, and all that part is heavy one. So we are not going to discuss them now. We'll discuss it a little later after we are more into the chapter and we know how and things are done. So after we know all that, then we are going to do that, right? So as I told you in the beginning, under section 149, we have to read 4 topics. So we have read about minimum and maximum directors, women director, resident director. Right? I hope you have learnt this much part. I'm sure you have learnt this much part. Just keep revising it in your mind. When you are brushing your teeth or when you are driving on road, whatever you're doing, keep revising it in your mind. And I hope you have written all 4 questions in your copy. That is very important. Fine. So we'll wrap up the class here itself. And in the next class, we will commence our next topic. Thank you.